Hi there. This training video covers the Protection of Personal Information Act, or POPI. Right, so we're going to jump straight into explaining exactly what this act is about. And we've all had this scenario that's detailed in the cartoon where it just feels like everybody's out to get your information for their own purposes. And the POPI Act was brought into play to protect us as individuals and legal entities and protect our information and how it's used by public and private bodies. This has been made possible by the creation of an information regulator, which enforces the POPI Act. And then there's quite a balance between a person's right to privacy as well as their other rights. So POPI attempts to balance these rights on a fair and reasonable basis. This act came into play fully on the 1st of July 2021 and does have many implications for us as a business. So please pay attention to what's coming up and particularly how we put this into practice and how we need to be aware of this in our day-to-day lives as we go about conducting our business. So firstly, the POPI Act is based on 8 different pillars. The first one is accountability, which means we as a company will be held accountable for the way that we use people's information. We have limitations on processing, so we may only use information in certain ways, and we may only use that for a specific purpose. In other words, we need to collect that information for a good reason. And an example of that would be we collect somebody's email address so that we're able to send them an invoice, but we're limited to only using that email address for invoicing. So we need to be quite specific about what we're doing there. There are also limitations on further processing. So that would mean we can't use that person's email address to sell to somebody else or to send them an email about something unrelated to our business that they did not consent to. We as a business are also responsible for the information quality, which means that we need to be sure to collect the information accurately from the person and make sure that it's correct. The 6th pillar is openness. So we need to be very clear and open with our clients about what information we're collecting and why we need that information and what we use that information for. The 7th is security safeguards. So we need to put certain things in place to make sure that the information is kept secure. And the 8th one is data subject participation. So they need to consent to us using their information, and they may also request a description of personal information that we hold. The whole crux of the matter is we may only collect the absolutely necessary personal information, and we may only use it for the correct purposes in a responsible manner. We cannot share that information or use it in any other way without the owner's consent. So basically, we may only use what makes sense for our business, and we may not use that information in any other way. Right, so what is personal information? In short, it's any information related to that person. Interestingly, medical history of an animal patient is not considered personal information, but it is governed by other confidentiality laws, which we'll go into detail about a little bit later. Right, so a little bit more detail on personal information. You can see there's quite a long list. So this would cover anything related to the person's race, gender, sex, marital status, color, sexual orientation, their age, religion, conscience, belief, culture, language, anything about that sort of intrinsic part of the person. It can also cover any information related to the education of the person or their medical, financial, criminal, employment history of the person. So this is important to remember when you get a phone call at reception from a company just asking to verify if somebody works there. You cannot actually give out that information without your colleague's consent. So just be aware of that. The 3rd category is any sort of identifying number regarding that person, or addresses or phone numbers, any ID numbers, those sorts of things. The biometric information of the person would cover anything about their body. So it would be their face, their fingerprints. So this is really important to bear in mind when we look at social media and we're putting pictures of that person on the internet. The fifth one starts becoming a little bit tricky and grey. It's the personal opinions, views, or preferences of that person. So these are things that people normally reveal to you in casual conversation, and we need to make sure that we protect that talking to others. Any correspondence sent by the person is can be deemed confidential, so that would be emails or WhatsApp, so we can't share that with others without their consent. And then the views or opinions of another individual about a person is also considered personal information. So if I give my opinion about somebody to a friend, she may not actually share that with somebody else without my consent. And then the name of the person, if it appears with any other personal information, is obviously also considered personal information. So you can see this is quite an extensive list, and it can get quite tricky. The important thing is to be aware of it and make sure that you're using that information on an ethical basis. Right, the other thing that I like to picture in my mind is this little dog with his ears covered. So it's almost like we hear no evil. So whatever information you hear, it's your responsibility to protect. So you need to be careful about what you share with clients and about clients to other staff members and other clients. So for instance, you may have somebody that walks out in a rage, and then another client asks you what happened. And you have to be very careful. You can't reveal too much detail. Or if a client in front of you tells you a story about a friend of theirs who's lost their job and is now bankrupt, and that person actually happens to be our client, we cannot share that information with somebody else. So we really, really need to be careful about what you hear. If we do share that information, there may be quite severe consequences. So we may suffer an enforcement action, which means that the information regulator can stop us from operating our business. We may be sued for civil action or damages. And the third, which is probably could be considered the least serious, but does have far-reaching effects, is reputational damage and loss of customers. So we don't want to have the reputation that we're gossiping or we're sharing information about people that we shouldn't. So please be careful about what you hear and what you do with that information. Right, so who does this act affect? It basically affects all of us in our day-to-day lives, and I'm sure you've come across the POPI Act everywhere you've gone. It affects our clients, it affects you as an employee, and it affects our suppliers and their information. So obviously when it comes to a business, you may share information about that business. For instance, if one vet shop has got a new supplier, there's no reason why you cannot share that supplier's information with another vet shop or with a clinic, because that's information is public. It's what the company wants you to use to contact them. But you wouldn't be able to share the CEO's cell phone number without their permission. That would be his personal information. So we just need to be careful about how we think about it. And you may have heard me say the word permission over and over and over, or consent. You need to really just get the person's permission before you use their information. And that's the bottom line. Right, so in the first slide, I said there's a balance between our personal information and the other interests of other bodies. And the POPI Act isn't the only act that affects our business. There are a number of other acts. So the first one that's specific to the veterinary profession is the Veterinary and Paraveterinary Professions Act. So that has got information in there that specifies what information we must collect in order to render a service. So that would include phone number, telephone number, email address, those sorts of things. It also specifies in that act that we need to keep the information for a period of 5 years after the patient's last visit. So that's in case we ever face, the wrath of the Veterinary Council and you get called in front of council because of a complaint, you need to keep that information and those records for 5 years. The second act is the Medicines and Related Substances Act, or Act 101 of 1965. So this defines the prescription of medication and records that need to be kept regarding prescriptions, and also defines what information we need to collect. So these two acts are the reasons why we are allowed to collect certain information about people. It's because we need to comply to these acts at the end of the day. And then the Farm Feeds, Fertilizers, Seeds and Remedies Act is quite a mouthful, but that's another one, Act 36, that does play a role in what we do day to day. And then the Basic Conditions of Employment Act and Occupational Health and Safety Act define what we as a business have to collect from you as an employee and what we do with that information as well. Right, so as I mentioned before, there are quite severe consequences of non-compliance of the Act. I think the highest fine defined by the Act is around 10 million Rand, which is something that none of us can really afford. So we really have to be aware of this Act and make sure that we comply with it. Information officers for each business have been appointed, and so that would be the person that's responsible for making sure that this act is carried out correctly in that business. And we have had some upheavals with that in the sense that an information officer can't be an information officer for more than one business. So in the vet shop setup, the information officers are automatically the managers of the business. So it's your responsibility, if you're a manager, to make sure that that vet shop complies with the POPI Act. And then in the clinics, it's one of the owners that have been appointed as information officer. As I mentioned before, there's severe fines or jail sentences for non-compliance. And it's at this point that I'd like to remind you about the values of the eBevet Group, which most people should know off by heart by now. But the last one, accountability, is really something that's one of our pillars of our business. And if we are living out those values of being accountable regarding a person's information, then we have nothing to worry about. So it's in every moment and every system, we need to just pay attention to, are we being accountable and are we complying with this act? Of course, these are consequences on a larger scale and on a business level. But if we find that an employee is not complying with the POPI Act, then that employee could face disciplinary action, and these would be considered serious offences. So you have now been made aware of that fact. Right, so we put a lot of things into place in our clinics and in our vet shops to comply with this act, and that started with an information audit, registering the information officers. We made changes in our AVMark, in our forms. We're doing training, which is what you are now going through. We've made changes to our website, and then a number of other changes throughout all the businesses to make sure that we do comply. Right. The next thing that I would just like to chat about is IT security and personal devices. So this is a potential minefield because this is where all of our information is kept at the end of the day. So when we look at particularly the AVMark system that we use in the clinics, where most of the information is collected, that data is encrypted and password protected. There are three potential places that we may have a breach of that information, where information may leak. So that would be clients seeing computer screens. So we need to be very careful that we don't have another client's information up when you leave the room, or that another person could see. When we look at our offsite backups, we literally are taking our whole database and putting it on a device and taking that offsite. And the reality is we live in South Africa and these things can get stolen. So if you are in possession of a hard drive that you're taking off-site, it's critical to keep that safe and to act responsibly with that. So you don't want to be going to a dodgy place at 3 o'clock in the morning with that backup in your car, and then your car gets stolen and the backup potentially gets stolen. So we do need you to be very responsible with that information. And the third possible place where we could have a breach would be in personal devices. So many of us are using our cell phones and our computers to do work on. So it's really important that you take personal accountability to make sure you keep those devices safe, especially if there's access to our databases. So your personal devices are required to be password protected. We'll also keep a register of who is using a personal device, so that we as a company are aware of that. And then we will need you to have certain IT security measures in place, and up your antivirus and those sorts of things need to be updated regularly, and our IT service provider will be checking that that's all in place. But obviously also practice caution, and you don't want to be sharing your passwords with people that they could access that information. It's general common sense. The other potential minefield is WhatsApp groups. So these are incredibly important communication tools, and one of the big things that we use to communicate with our large team on many sites. But it's really important that we don't share any client or personal information on these groups. So you don't want to do screen grabs of clients' information onto a WhatsApp group. And then a huge no-no would be forwarding personal information to another person from a business WhatsApp group. So we also have a register of all of the business WhatsApp groups that are monitored, and those types of breaches would be tracked back as well to those groups. So it's really critical in those groups to keep that information confidential. Right. And just before we move on to this, it's also important to realize that your colleagues' information is also private and personal. They have the same rights as what a client would have. So you cannot share a colleague's opinion or their phone number or anything like that without their consent. Right, so how do we deal with a breach? Now, this is something we do everything that we possibly can do to prevent, but it is a possibility. So should you become aware of a leak in information to someone or someplace, you need to inform your manager immediately, and you know that chain of command. A full assessment of the breach will be done, and then we'll just assess who was affected and implications thereof. Any persons affected by the breach will need to be contacted. So this also does depend on the scale. In theory, if our whole database leaks, we would need to contact every single person on that database. So it does have far-reaching implications, and important to keep that information as safe as possible. Should we, in our assessment, find that there was negligence or an employee was not accountable with information, that employee could face potential disciplinary action. And then we use this as a learning curve as well, so we then can implement changes to ensure that it doesn't happen again. So it's important to then share this information across the board so that every business entity can learn from it, and that we can prevent such a breach from happening in the future. Right, paper information is a whole other story. We need to keep this information securely in a locked cupboard. It needs to be destroyed if it's older than 5 years, so it needs to be shredded. And this would include any piece of paper with personal information on it. So new client forms, patient records, lab results, employee information, CVs, any piece of paper that has any information on it, basically. So that's quite important to implement. Right, so we've spoken now a lot about our clients, but it's also our responsibility as employers to be open and accountable to you as an employee and share what we do with your information. So we keep your information securely on password protected devices. You'll see on your contract that there is a long addendum explaining what information we keep and how we use it. and it's also details in there how we expect you to use other people's information, and that you agree and will comply with that. In that addendum, you'll also give consent to us sharing your information with third parties. And third parties would include companies such as AdminWiz, which prepares your salary slips, Thrawn du Plessis, which helps us with our tax and financial statements, and Team Dynamics, which helps us with our HR. And then obviously other regulatory bodies which we have to share information with, which would include SARS, the Compensation Commissioner for Injury on Duty, and workmen's compensation is that one. And the Unemployment Insurance Fund, that is the one that I couldn't remember. So, when we're required to send information to them, then you will have consented to that already in that addendum. Should you have any queries or you're concerned about any of this information, please let us know. It's critical that we are aware of it so that we can make the necessary changes. Right, so a note on ethics. It's really important to listen to that voice inside yourself. If you have to think, I wonder if it would be right to share this information, then just pause, don't share it. Talk it through with your information officer or your manager first before you do so. And it's really great to have these conversations so that we can chat through these different scenarios and decide how we're going to deal with them moving forward. Right, so the next section of this talk is more focused on the clinics, but I think it's important for the entire group to be aware of this, and we may have people working in clinics and vet shops, so it's really important to be aware of it. First of all, in the clinics, we collect and process a lot more information than one would do in a shop setup. So the first thing that we've been saying over and over and over and over is we need to get a client's consent to use the information and explain what it will be used for. So our new clients have to fill in a new client form, and there's terms and conditions on that form that explain how we're using the information, and then they may opt in and out of certain options. As a receptionist, it's critical that you record all of this information correctly. Remember, we're responsible for the information quality, and it's critical that you are able to explain to the client why we're collecting that information. So if they ask, why do I need to put my ID number down here? It's because the Medicines and Related Substances Control Act requires an ID number before we may prescribe medication. So, we don't ask for any information that's not required by law. So you can be very firm on that, and there are legal reasons why we collect that information. Our existing clients, we're busy with updating our entire database regarding our existing clients. So first of all, they need to get existing clients forms so we can check their details, that they can also consent to the terms and conditions and opt in and opt out of their communication options. So again, critical to record this on AVMark and to be able to explain it to the client. You can also refer the clients to our privacy policy on our website, so there's a lot more information on there. I'd like to highlight a potential complication around the question of alternative contact people. So this is one of those where we are asking somebody to give contact information of another person, and it's implied that that person would have permission from the other person before they share it with us, because it's normally a spouse or a family member. We are covered legally because should we not have an alternative contact person to contact in the event of an emergency, it would be deemed negligent. So that is the legal basis for us asking for that alternative contact person. And then, as mentioned before, clients have the right to see what information we have collected. And this is particular to their personal information. So remember, their pet's medical history is not personal information. They do not have the right to see their pet's medical history. That belongs to the vet who wrote it. So really critical to have that distinction. The client may see their name, their ID number, their address, their phone numbers, that's the information that they have a right to see, but they may not see what notes the vet wrote about their animal. So obviously we will be open with them because that is part of our values, but a vet needs to be able to decide how much of their notes they are going to share with the person. And then we do need to see proof of identity as well. So we need to ask for clients to show their ID when registering at our practice. Okay, so what do we use the information for? There are certain things that are not optional for the client. So we use the information to be able to contact them regarding their pet's health status, to contact them regarding their account. We also use the information to send them a welcome letter. And then in the terms and conditions, they consent to us sharing the history of their pet with the relevant animal health care providers. So those would be things like referral clinics or cremation companies or labs, those sorts of things. So obviously we need to share that information in our normal course of business, and that's reasonable. What is optional for the client is to consent to the use of their information on social media, consent to having a survey sent to them, and reminders and newsletters, and then any promotions or product offers. And then that consent is given through the opt-in table on their forms. So it's really critical to record these selections on AVMark, because there's nothing worse than somebody saying they're opting out of a survey and they've written that on a form and then we send them a survey. So it's really critical to make sure that information is correct, which is one of the pillars of the POPI Act. Right, so we've mentioned medical histories before. And this is a potential minefield. So we need to practice caution with sending histories to other clinics. Although in our terms and conditions, we specify that we may send that information and that they consent to that, still practice caution with doing that and still get verbal consent before you send a history to another clinic. And also make sure that history only contains the relevant information for that case. So there's no reason why you would share that the person is a bad debtor. We're not allowed to share any financial status with anyone else without their consent. So what sort of information would another clinic need from us to be able to treat that animal? It would be the person's name, surname, and phone number. There's really no other personal information they need from us. They can collect all of their own information and take accountability for that information. So that's really critical that we are careful about that. And then, as I mentioned it before, and I'm highlighting this again, you never, ever, 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 ever share clinical notes with a client unless the vet on duty is 100% happy with that. If a client requests their own medical history, then they are allowed to get a summary of the history and not all of the vet's notes. Those notes, and I'm saying it again, are the property of the vet. So should the client want a record of the history and not another clinic, then you inform the vet and the vet can then create a summary for that person and decide what information they may or may not include. And this, should you share a full history with all of the vet's clinical notes, that really opens the vet up to liability claims and things like that. And clients don't always understand those notes. So it's really important not to share the notes with the client. And should that happen, that would also be an event that would attract disciplinary action. The other place that's a little bit of a minefield that comes with medical histories is medical aids. So medical aids, as we know, are quite sticky about what they cover. And we don't want to get into a position where we're in the middleman with information. So should a client request or a medical aid request history on a patient, it's important for the vet to draft a summary. Once again, not the whole notes of the vet, because sometimes the vet will mention something they were thinking about, but the animal was never diagnosed with, and then the medical aid will exclude on that basis, which is not fair for the client. So the vet will then draft a summary, and then that summary needs to be sent with the client for the client to consent to it before the information is being shared. So the best way to go about that is to get the client to forward that information onto the medical aid. So that's really important to bear in mind. Right, it's quite a mouthful and quite a lot to think about. So should you come up with any particular scenarios or questions around the POPI Act, be sure to ask your supervisor or pop me an email so that we can discuss it. And it may be something that's actually really important that we haven't thought about, that we need to chat to everybody about. So please don't keep that to yourself. All questions are important. And please let us know how things go moving forward. Hope you have a lovely day.